Eventually, the CMS got back to her and they said, "You're in the wrong place, sweetheart. You gotta file a complaint with the Illinois Department of Financial and Professional Regulation." Over 6 months later, Anna sued the doctor and the hospital in Illinois state court for malpractice. What she didn't know at the time was that because the hospital technically got some taxpayer money, the US government would substitute itself for the defendant and bump the case up to federal court. Anna had no lawyer. She was representing herself, but her little homebrew legal case was now Coney versus United States. Without meaning to, she was suing Uncle Sam. The relevant law in this case was the Federal Tort Claims Act, which says that you cannot sue the government until you have exhausted all administrative remedies. So suing has to be your last resort. First, you have to make a claim to the department and then give them time to think about it, maybe offer you a settlement before you jump right into suing them. The government lawyer said that Anna had not done that. She sent the letter with all the attachments, she mentioned restitution, and one of the attachments talked about $332, but apparently that doesn't technically count as making a claim. And so they filed for a motion to dismiss the case, and the judge granted it. But Anna Coney hadn't come this far to back out now. She appealed that decision all the way to the 7th Circuit Court of Appeals, where it came in front of Judge Amy Coney Barrett. Barrett was appointed to the appeals court by the Trump regime in 2017. It has been quite difficult to write a video about her because the situation in the US is changing so fast. But I mean, look, the script is clear. I'm just gonna have to apply the original meaning of the text, even as the facts change and it becomes outdated. Barrett is an originalist. Originalism is a philosophical method for interpreting the Constitution and laws of the United States. You see, in the US, they have this thing where 300 years ago, they were like, we want to be independent. And then we, the British, we were like, we're trying to save the world from Napoleon? We'll call you back. And then they did it. And then Thomas Washington, he wrote the Declaration of the Constitution. It's a special piece of paper, and then now they all have to do what the piece of paper says, and then they sang a big musical about it. Alexander Hamilton. I'm not sure that's right. I think I need an American.
Hello.
Devin, thank you so much. Whilst I enjoy this deliciously illegal haggis, would you explain to the boys and girls about Thomas Washington and the Constitution?
Thomas Washington? I think you're thinking of George Jefferson. But yeah, the American system of governance is, to put it mildly, interesting. It is, as you probably know, a constitutional democratic republic. So we have a whole system of government, but theoretically at least, it's bound by the Constitution. That is the highest law of the land. And the American government has 3 branches of government. We have the legislative branch that is made up of the Senate and the House, which writes the laws. We have the executive branch that's headed by the president that effectuates the laws. And then we have the judicial branch headed by the Supreme Court of the United States that interprets both the laws that Congress passes and also the American Constitution. And the Constitution theoretically provides an outer bound to what the entire US government can or cannot do. And theoretically, the legislature can't pass laws that violate the Constitution, nor can the president do action that violates the Constitution. So there are advantages and disadvantages to this approach. If there are things that you think are really, really important and you're worried that there are certain majoritarian tendencies that are going to prevent those principles from being effectuated, then you might want to enshrine those principles in the Constitution. For example, if you wanted to protect certain minority rights, then you might put those in the Constitution so that no matter how hard the legislature tried, or no matter how whipped up the populist fervor was, they couldn't contradict the law of the Constitution. But there are disadvantages to that as well, which is that if you really disagree with the ideas and principles that are enshrined in the Constitution, it's really hard to change those. You'd have to amend the Constitution, which happens from time to time in the US. It hasn't happened in a while, but it's incredibly difficult to do. Specifically, you have to have a supermajority in the House and Senate, and then it has to be ratified by 38 of the US states. That's not the only way to organize a democracy, but that's the way the US has decided to do it. And you see this being played out in the news media all the time. So for example, the United States has the First Amendment, which ensures a number of different freedoms, but among those is the freedom of speech. So the US government cannot infringe certain rights of speech. The UK government does not have that particular protection, but the UK government generally protects citizens' right to speech through legislative acts and statutes and laws. The US has those as well, but at the end of the day, the First Amendment to the US Constitution enshrines those particular principles in law, and it's very, very difficult to go against the individual right to freedom of speech. Of course, there are counterexamples of this as well. A lot of people would argue that it's crazy that the US has the Second Amendment, which allows an individual right to freedom to bear arms, or at least that's how the Supreme Court has interpreted it. And there's not a lot that the legislature can do. Even if you assume that a majority of US citizens were in favor of gun control, for example, which I don't know if it's true or not. Let's say it was true. There's not much that you can do if the Second Amendment provides an individual right to bear arms. So a constitution makes change very, very difficult, which can be a pro and a con. And there's certainly a lot of people in America who think that the Second Amendment protections are actually even more important than the First Amendment protections. But that makes the stakes of who is on the Supreme Court incredibly important. There are 9 justices on the US Supreme Court, and generally speaking, the US Supreme Court makes decisions about interpreting the US Constitution, and often interprets the most important laws in the US. And so who makes up those 9 justices can be very, very important. And that can actually change the understanding of what the Constitution means and what it stands for. And if you control the interpretation of what the Constitution means, then you can change the interpretation of what the Constitution does. And so you can imagine that if the stakes are that high, that if you are changing or at least interpreting the meaning of the most important legal document in the United States, that people are going to care a great deal about who is actually making those decisions and on what basis they are making those decisions.
Thanks, Devin.
Sure, no problem. Happy to be here. Are you okay?
Yeah, I'm fine. So, back to the story. Anachronis is suing Uncle Sam for her $332. The case has come before Amy Coney Barrett, and Barrett is an originalist. We have to be careful here, because there's originalism the theory, which is about interpreting the law, originalism the political ideology, which is about using the law to get what you want, and originalism the cultural vibe? And they all kind of blur into one sometimes. Correspondingly, there's Amy Coney Barrett the judge, Amy Coney Barrett the political figure, and Amy Coney Barrett the cultural symbol, and they also blur into one. But I promised to try and be as neutral as I can, so let me give you the theory for now. We'll get to the other stuff. There's different varieties of originalism. It gets technical, but let me break it down real easy into 2 key points. Point 1. The meaning of the Constitution was fixed at the time it was ratified. Let me ask you this. It sounds like a real philosophy jack-off question, but what does the word meaning mean? Put yourself in Anachronis' shoes, thinking about her $332 and the Federal Tort Claims Act. She might wonder, what does the law mean for my case? i.e., what's gonna happen? She might wonder, what did the authors mean when they wrote it? What were they trying to do? Or she might ask, what do the actual words mean? When the law says Americans have the right to bear arms, does that mean arms as in weapons? Does it mean arms on their bodies? Or does it mean they have a right to bear arms, the arms of bears? When originalists like Barrett say the meaning of the Constitution is fixed, they're talking about that third kind of meaning. What do the words actually refer to? You can look at the text itself to figure it out, or other historical documents that might shed light on how the words were used at the time, but according to the law, Anachronis has to exhaust all administrative remedies before she can sue Uncle Sam for her $332. So the question is, what exactly does all administrative remedies mean? And if you were in Anna's situation, you might well think, why do we have to have a debate about the meaning of words? Can't we just try and address the problem? But I will tell you why with a controversial example. The Affordable Care Act, also known as Obamacare, was an American law passed in 2010. To a haggis-eating foreigner like me, these